Good evening, members of the panel. My name is Brandon Zhang, and I am with my co-counsel, Mark Maxwell Peter. We appear on behalf of the appellant, Mr. Antonio Fortuna. I will speak on two issues: the statement of appeal and whether my client's refusal to hand over his mobile phone was lawful. My co-counsel will then speak on the anonymous email and witness statements and whether the appellant violated Article 20 of the FCC. I'll speak for 10 minutes and reserve 1 minute for rebuttal. Members of the panel, the respondent has imposed a sanction on my client for the alleged involvement of match fixing without regards to fundamental rights of my client and has not sufficiently proven that my client was guilty of any of the offenses. And as a result, we appear today before the panel to ask that it reverse the FIFA's appeal decision. Turning now to the first submission. The question is whether the statement of appeal is admissible, and this arises because the day of the receipt is in dispute. It is our submission that the statement of appeal is admissible for two reasons. First, the day of the receipt is 2nd April 2026, and second, we have submitted Exhibit 9 to show that the statement of appeal was submitted prior to the deadline. In the 2016 CAS decision of Ivan Bellado Palacios versus PFC.
Sorry, Counsel, before you go to the cases, can you lead me to the CAS code provisions on admissibility? Or the timelines, we're talking about timelines now, right?
Yes. In paragraph, if I can direct the panel to paragraph page 5 of the record here at paragraph 26. The decision was fully upheld on 31st March by FIFA. However, the challenge decision with full grounds was sent on 2nd April 2026. And pursuant to Article 15, subsection 2 of the FIFA procedural rules, it explicitly provides that the time limit begins upon receipt of the full grounds of decision. And
sorry, what does Article 15?
Article 15, subsection 2 provides that the notification is deemed complete when the decision is communicated to a party, and subsection 4 states that decisions that immediately impose sporting sanctions against the party shall only be communicated with grounds. And here, the day of the receipt of decision with grounds.
Sorry. Before we get there, you're referring to the FIFA. What code is it again?
It's the FIFA Procedural Rules 2025 edition.
Procedural rules.
Procedural rules.
In relation to disciplinary.
Yes, because the dispute is over the day that the timeline begins.
But why is the Court of Arbitration of Sports bound to the FIFA rules? I'm bound to the CAS code, aren't I?
Well, it states that in the absence of the relevant article is Article Rule 49 of CAS code, which gives a 21-day time limit in the absence of any rules by the sports governing body. But here, the FIFA rules under Article 50, subsection 1 is also 21 days. So the timeline is 21 days, pursuant to both of the CAS code and the FIFA rules. And the dispute is whether the triggering day is the April 2nd, the full grounds, or rather the operative motivated or the operative decision. In the 2016 CAS decision of Ivan Bellado versus PFC, at paragraph 74, the panel observed that Article 15, subsection 2 of the Procedural Rules 2008 edition provides that the timeline to appeal begins upon receipt of the motivated decision, which is also the full decision full grounds as back in 2008.
What's the definition of motivated decision?
The motivated decision is the decision that is given but without the full legal reasoning, the reasoning behind the decision.
So in other words, it sets out the grounds of the decision, but it doesn't explain why it comes to the
It doesn't, yes, that's correct. It doesn't give the full legal reasoning.
And where do you get that definition from?
That is a general definition, but there is that is a general definition.
Okay, I think there is somewhere which actually defines what motivated decision is.
Certainly,
If you don't have it now, that's fine.
certainly.
You can take a look at the. I think it is in one of the FIFA codes.
I will look at the FIFA codes there. In that case, the panel held that it was the day of decision with full grounds, which triggers the 21-day time period, and held that it was the statement of appeal was admissible. And in the present case here, we submit that it was filed within the 21-day time period, and that is reflected at paragraph 26 of the record, Exhibit 7, and the appellant there also paid the fee and filed the statement at 23:34 Iridonian time, and therefore it is our submission that the appeal is admissible.
23:34.
23:45 on the last day of the timeline and pursuant to Article R32 of the CAS Code, I quote, "The time limits fixed under this code are respected if the communications by the parties are sent before midnight, time of the location of their own domicile."
So midnight is specified.
It is specified, yes, under Article R32 of CAS Code. And Iridonian shares the same time code as CAS, pursuant to the footnote number 3 on page 5 of the record.
Okay.
If there are no further questions, I will turn to the second argument here. In the alternative, it is our submission that even if the panel does not take that to be the day of receipt, we submit that it still it can be cured because we had submitted Exhibit 7, which was the email, to show that it was the email was sent out at 23:45 because there had been a cyber attack, and that cyber attack had because of the cyber attack, the email was not sent out. And I would like to introduce the CAS decision, the 2013 CAS case of AC Siena SPA versus Club Desportivo Nacional at paragraph 39. The appeal was filed 1 day later. However, the appellant submitted a shipment waybill receipt as evidence that it had been filed on the 19th, picked up by the Italian courier company on the 19th, and at paragraph 42, the panel held that the appeal was timely filed and thus admissible. And therefore, in the present case, particularly if I could ask the panel to follow me to page 5, paragraph 31, here it states,
31. Okay.
yes, page 5, paragraph 31, thank you. The statement of appeal was filed by email specifically sent to the relevant email address at 23:45 Iridonian time on 23rd April 2026. This is Exhibit 8. And here we have submitted this evidence which proves that indeed it had filed the statement of appeal within the 21-day time limit, and therefore it is our submission that the statement of appeal is admissible. If there are no further questions from the panel, I will turn to submission 2. The respondent imposed a 5-year sanction and a fine of 100,000 Swiss franc when my client refused to provide his mobile phone to the investigation committee. It is our submission that the refusal was lawful for two reasons. First, the evidence does not sufficiently establish my client was involved in match fixing, and second, the privilege of self-incrimination is applicable. So turning to the first submission, we submit that my client, Mr. Fortuna, had not colluded with his father, and that the evidence is insufficient and can be rebutted. If I may direct the panel's attention to Exhibit 6 of the record.
Are we going to the facts now?
Yes.
No, I just wanted to hear what rules of evidence is the panel bound by?
Yes, panel. The Incas jurisprudence has held that the standard of proof is a comfortable mere satisfaction of proof, more than a probability, more than a balance on probability, but less than beyond a reasonable doubt.
So where does that wording come from? Comfortable satisfaction. I mean, that is just one rule of evidence. I'm asking about what are the rules of evidence I am supposed to be bound by.
At this juncture here, I am not able to make any submissions on the rules and evidence.
Even the one on the threshold of comfortable satisfaction.
Well, that one merely just states that it doesn't have to prove it beyond a reasonable doubt.
So where do you get it?
That has been held in multiple CAS decisions.
And the multiple CAS decisions have not mentioned the provenance of that rule? Or you haven't seen them say such things?
I'm not quite sure which specific issues you're asking.
No, because you are saying that there's a threshold of comfortable satisfaction before I can say that there's an offense which has been out. Where does that come from? Where can I see it? Could it be in the FIFA code somewhere? Could it be in the CAS code somewhere? Because right now you're telling me that you got it from cases, but surely the cases would have referred to some source of those of that rule itself. It's okay if you cannot find it right now, but just keep in mind there's a common question that arbitrators will ask.
Okay, thank you. So in Exhibit 6, at paragraph 14.
Oh, so we're going to the facts now, is it?
Yes.
Okay. Paragraph 14.
Exhibit 6.
Which page?
Sorry, page 14, Exhibit 6 of the. It is Exhibit 6, but it's also reflected.
I have the mood problem with there's a total of 57 pages. Which page should I refer to?
Page 15. 14. Page 14. That's correct. Sorry, page 14.
Page 14. Okay, I'm there.
You're there, right?
Yeah. Well, what am I supposed to
get? If the panel can turn to page 15. Sorry, page 15. At the bottom, paragraph 6. Here.
Hold on. I'm at page 15 of the record itself.
Okay. The bottom, paragraph 16.
I do not see a 16.
Okay. 16.
Well, what document are you referring to?
I'm referring to Exhibit 6, the document.
Exhibit 6. Okay, let me go to the index. Oh, there's no index. Is there?
Uh,
Hold on.
I will find the relevant paragraph in the record.
No, Exhibit 6, the witness statement of Mr. Fortuna.
Yes.
6, okay.
Paragraph
I missed
16.
6.
It's also paragraph 19, page 4 of the
Hold
record.
on, okay, I see 15. 16, yeah, go on.
So in paragraph 16, he states, I quote, "We tend to let conflicts simmer between us on basically any topic, and we may end up arguing on my diet or the way I decided to decorate my living room." And here, the appellant explains that he and his father may argue on any topic, and with respect to Exhibit 2, I quote, "In Exhibit 2, I recall hearing Mr. Antonio Fortuna telling his father to stop pressuring him, shouting that he simply could not go along with him in everything." And according to this statement, it directly contradicts any allegations for 2 reasons. First, it could be an argument over anything, and it is our submission that the inference drawn by FIFA has been too high and is not reasonably drawn. And second, the appellant directly refuses to do anything his father had asked him to do. And therefore, for those 2 reasons, it is our submission that the FIFA Appeal Committee had not demonstrated any real sufficient evidence to inference and conclude that the appellant had engaged in match fixing, particularly with his father. And
Sorry, I'm getting a bit confused. So, we are saying right now that the player's refusal to hand over his mobile phone
yes,
when requested because of the investigation, that is a breach of some regulation,
yes,
which caused FIFA to impose some sanctions on him.
correct,
That is in addition to the match fixing.
yes.
Right. So again, what regulations am I looking at?
The relevant regulation is Article 12 of the FDC,
Okay, disciplinary code.
of
Okay.
the FIFA disciplinary
Which is
code.
different from the earlier one you stated, right? There was a
Yes.
procedural code.
That would, yes,
Okay.
that's a procedural code. So the Article 12 is the relevant code, which does state that it falls that there has to be cooperation when requested to provide evidence. And here on this argument, we merely just assert that.
So Article 12, right? You say
Yes.
Does it have any exceptions stated therein where the player can rightfully or lawfully say that no, you will not have my mobile phone or my devices, or has any other cases explored this particular provision or similar provisions where the player can raise his hand up and say, no, you are not entitled to get it from me?
Thank you, Mr. Presiding Arbitrator. And this brings me to my next submission, is the privilege of self-incrimination. In Article 12 of FDC, there is no exception stated there under the FDC. However, in the 2017 CAS decision of Jerome Malk versus FIFA, at paragraph 226, it states, I quote, "Where there are concurrent disciplinary and criminal proceedings, the privilege against self-incrimination appears debatable. In such a case, there is a real danger that the sports organization will be misused by public authorities to collect information that they could be otherwise unable to obtain. And in such circumstances, there may be, in the view of the panel, a valid claim by the party or witness concerned to refrain from delivering self-incriminating information." And in the 1996 European Court of Human Rights case of Funke versus France, at paragraph 41, the court held that the conviction by the criminal court for refusing to disclose the documents requested by the customs officer had violated his right to a fair trial under Article 6 of the ECHR and disregarded the presumption of innocence under Article 6 of the ECHR. And therefore, it is our submission that the my client, Mr. Fortuna, had been violated of his right under Article 6 to a fair trial when there had been a sanction imposed upon the refusal of his mobile phone. And this is supported by Article 26 of the Swiss Civil Code, which is a procedural right as well under Swiss law. And therefore, in our present case, it is our submission that my client had a fundamental right to refuse evidence which may incriminate himself as well as his father, to refuse. And
Sorry, you say you keep saying fundamental right. Can you give me some examples of what are fundamental and non-fundamental rights?
So one example is the right to a fair trial under Article 6 of the ECHR, and also Article 8 of the ECHR, which is a right to privacy. And here it is also arguable that there was a violation of the privacy of a right of privacy in requesting that my client hand over his mobile phone.
Is the right of privacy something that I have to consider as, what law am I considering under?
The CAS panel has considered and has stated that the Article 6 of the ECHR must be taken into consideration. For example, in the 2011 CAS decision of Amos Adamu versus FIFA, at paragraph 66, I quote, "The panel is mindful that some guarantees afforded in relation to civil law proceedings by Article 6 of the ECR are indirectly applicable even before an arbitral tribunal. All the more so in disciplinary matters because the Swiss Confederation, as a contracting party to the ECHR, must ensure its judges guarantee a fair proceeding within a reasonable time." And the court then concluded and stated these procedural principles thus form part of the Swiss procedural public policy. If the panels have no further questions,
I think you haven't answered the second part of my question, which is what are non-fundamental rights?
What are non-fundamental?
Because you say there are fundamental rights like right to a fair trial and so on. So what are non-fundamental rights?
So non-fundamental rights would be non-fundamental rights, for example, could be when requested to make a statement, such as in our case, the appellant was requested to make a statement, and he did in fact make a statement, and this is Exhibit 6 of the records.
So sorry. So what was this? So what is the right we're talking about here?
The right we're talking about here is the right to a fair trial. And here we argue that that right had been violated because
Sorry, as in you're saying there's a fundamental right that I recognize. Well, what is the non-fundamental right you're trying to talk about?
the non-fundamental right would be, say for example, the refusal to provide a witness statement, a direct witness statement.
Yeah, okay.
I may defer to my further submissions there, Mr. Arbitrator.
Okay. Anything else?
This brings me to the end of my submissions.
All right.
Good morning, members of the panel. My name.
Really morning? I thought your opposing counsel said was evening.
Apologies,
I'm very
Mr.
confused
Arbitrator. Good evening, members of the panel. My name is Seah, and together with my co-counsel, Mr. Ramesh Kanna, we appear on behalf of the respondent, the Federation de International Football Association, FIFA. I'll be speaking on the first two issues on appeal for 10 minutes, namely whether the statement of appeal is admissible, and secondly, whether the appellant's refusal to hand over his handphone was unlawful and the possible legal consequences that may ensue. My co-counsel, Mr. Kanna, will address the remaining two issues for 10 minutes, and we reserve 1 minute for a rebuttal. Members of the panel, integrity lies at the very heart of football as a regulated sporting activity. The effective enforcement of disciplinary sanctions, coupled with the mandatory duty to cooperate with investigative processes, is indispensable to maintaining public confidence in football. Any conduct tainted by corruption strikes the foundation of the game and is fundamentally irreconcilable with these principles. Today, the panel is faced with two choices. It can either affirm the sanctions duly imposed in defense of football's integrity, or they can choose to undermine the very mechanisms designed to protect sport from corruption and manipulation. In such circumstances, the sanctions imposed were not only warranted but proportionate, and the respondent therefore respectfully submits that the appeal must be dismissed. Turning to the first issue, we submit that the statement of appeal filed by Mr. Fortuna is inadmissible for three reasons. Firstly, the appellant had missed the deadline to file the statement of appeal. Secondly, the decision on 31st March is an appealable decision, making the deadline 21st April. And lastly, the appellant had missed the deadline to file the appeal brief. Turning to the first argument, we agree with counsel for the appellant that Article 50, subsection 1 of the FIFA statute is applicable here. And as noted in the 2023 CAS case of Wolverhampton and FIFA, and the 2006 CAS case of WADA and FPF, it suffices that the addressee had the opportunity to obtain knowledge of the decision. Whether or not the addressee had the actual knowledge of the content of the decision is in itself irrelevant. And in the present case, if I may turn the panel's attention to paragraph 23 of the record located on page 4 of the facts.
Sorry, hold on. Page 4 of the moot problem.
Yes, paragraph 23. The decision was fully upheld on 31st March 2026 by the FIFA Appeal Committee. Therefore, the appellant and his legal counsel would have had the opportunity to obtain knowledge of the decision on 31st March 2026. Therefore, the relevant date...
Sorry, I'm getting a bit confused. I'm looking at...
Oh, apologies, Mr. Arbitrator. I meant paragraph 26.
26.
Located at page 5.
31st of March, apparently. Okay, go on.
Yep. And therefore, the relevant date which triggers the statutory 21-day time limit begin on 31st March 2026, making the deadline 21st April. And as a result, the appeal filed on 23rd April, which can be seen on paragraph 27 of the record, was evidently late.
So how many days was it late by?
It was late by 2 days, Mr. Arbitrator.
2 days?
2 days.
And for that, you want to throw out the appeal?
Well, in respect of this, we do agree that the CAS has been able to allow the extension, not allow the extension of this, but reinstatement of certain submissions of documents in light of the failure to submit their documents on time following the deadline. However, the issue of reinstatement is that it can only be granted on very, very specific circumstances. And we argue that it cannot be granted in this case. Firstly, the appellant had failed to act promptly and diligently, and secondly, the appellant had failed to prove that the delay was due to no fault of its own. As found in the 2024 CAS case of SC Football Club and Galatasaray, a lack of timely action by the council, even against the backdrop of technical issues, creates the fatal presumption that the party simply missed the deadline for no good reason. And there was ample opportunity for the council in that case for the appellant to request for reinstatement.
I'm sorry, so in that case, was there a security breach? breach, cybersecurity breach?
There wasn't a cybersecurity breach. However, we are focusing on the issue of promptness, as noted to be a key requirement for the requestment of reinstatement.
Because earlier, I think your opposing counsel did mention that there was some delay due to the cybersecurity incident. But if that was not the case, it would have been on time, right?
Yes,
If I heard
but
you
we have to consider the nature of the cybersecurity incident because counsel for the appellant has not given the full picture of how the events had unfolded. Firstly, even if we disregard the cyber attack, the inherent nature of emails is that if it had indeed been sent, they will be found in the sent folder of the counsel's chat. And even without an error message, the fact that such an email notification was absent indicates that CAS likely did not receive such an email. And if I could turn the panel to para 27 of the record, located at page 5,
Yeah.
the appellant's legal team have filed a highly sensitive statement of appeal at 23:45 Iridonian time on the final night. If we do take the appellant's position that the deadline was 23rd April himself, and consider the deadline of the filing 15 minutes before the deadline was to elapse.
But what's wrong with that?
We are submitting that because the legal team had proactively failed to verify receipt or to follow up immediately to ensure that their statement of appeal was received by the CAS, they should have already contacted CAS to ask for reinstatement at this juncture. And we have
At what time should they have asked for reinstatement?
we submit that it was on the night itself because the deadline would have elapsed, and by the time midnight has passed, they should have checked whether their statement of appeal was actually sent to the CAS.
So how and at what time do you think is the right time or right manner to ask them so that they don't fall foul of this? Because the fact is that they did send it.
They did send it,
Yeah.
okay, but however, we will submit that even if we if we do consider the nature of the cyber attack, we have to look at when the cyber attack was made known to the appellant. And in this respect, if I could turn the panel's attention to exhibit 9, located at page 19. I understand that the mode problem may not follow the specific.
Okay.
It shows a screenshot of the WhatsApp message between the appellant's counsel and its IT provider.
Exhibit what again?
Exhibit 9.
9. Let me search for exhibit. Okay, that's page 52 of the record. Yep.
Yes. Mr. Fortuna was informed of the cyber attack and its possible consequence on 26 April. Yet, they waited until Tuesday 28th April, and this can be seen at para 29 of the record at page 5.
Sorry, I'm looking at the WhatsApp. Cybersecurity recently occurred. That's on 26, so that was after the incident.
That was after the incident.
Okay.
And then we have to consider when they made known to the CAS that this cybersecurity attack had actually taken place and when they asked for reinstatement. And this can be found at para 29 of the record.
That is page 5, right?
Para 29 and 30 for the full picture, Mr. Arbitrator.
26, okay. Yet to acknowledge receipt. So 26 is what day is 26?
26 is a Sunday, Mr. Arbitrator.
Alright. So 24th was a Friday. Correct?
Yes, Mr. Arbitrator.
So if I send it on, they send it on 23rd or 24th?
You mean informing the CAS for
No, as in
reinstatement?
when did they file it?
They officially filed it on 23rd April at 23:45.
Okay, so that was Thursday, Friday, sent by courier.
Yes.
Okay. I mean, the timelines look a bit. Okay, so you are expecting people to work over the weekend and reach out.
Actually, if we do consider that the weekends are to be kept sacred for the CAS members, they should have filed their query on the 27th of April, which is Monday, a working day. So in respect of that, despite knowing that they had a cyber attack on the 26th and having the opportunity to inform CAS immediately and inquire of them whether the statement of appeal has indeed been sent, they only inquire of them on the 28th of April. And promptness is noted to be a key requirement for reinstatement. And unless I may be of further assistance on the first issue,
No, I'm good.
I'll turn to the second issue. We submit that the appellant's refusal in handing over his phone was unlawful for 3 reasons. Firstly, the appellant had breached the non-negotiable duty to collaborate under Article 12, subsection 5 of the FIFA Disciplinary Code. Secondly, Article 6 of the European Convention on Human Rights is inapplicable to our proceedings, rendering the appellant's defense of self-incrimination inapplicable. And lastly, even if the privilege against self-incrimination is invoked, it is insufficient to justify his refusal. Turning to our first argument, the FDC imposes a clear, non-negotiable obligation on all participants to assist in establishing the facts of a case, especially when the integrity of sport is at risk. According to Article 12, subsection 3 of the FDC 2025 edition, persons subject to this code shall help to establish or clarify the facts of any case or any possible breaches of the code, and in particular shall provide any evidence as requested. And this is an absolute duty as noted in the 2022 FIFA decision of Chilean Football Association and Peruvian Football Association at para 131. And if I could then turn the panel's attention to para 20 of the record, located at page 4 of the facts. Mr. Fortuna immediately refused to cooperate when FIFA's representative requested that the appellant submit his mobile phone for the purposes of their investigation, a clear violation of Article 12 of the FDC. And secondly, we understand that counsel for the appellant has raised the right against self-incrimination. However, the appellant's reliance on Article 6 of the ECHR fails because FIFA's investigation is disciplinary and not criminal. If I could turn the panel's attention to para 15 of the record, located at the same page, page 4. Yeah. The investigation into the appellant is merely disciplinary, and hence Article 6 is not applicable, and this is supported by CAS jurisprudence. In the very case that the counsel for the appellant has cited, the 2017 CAS decision of Jerome Valky and FIFA at para 263, the guarantees recognized in a criminal trial are inapplicable per se in a disciplinary proceeding before the CAS, since FIFA is a private entity and the sanction imposed by the appellant is purely private.
I'm sorry, I didn't quite hear you saying the guarantees.
The guarantees recognized in a criminal trial are inapplicable in a disciplinary proceeding before the CAS.
What kind of guarantees are we talking about? Sorry.
The guarantees in our case that we are contending here is the defense of self-incrimination that the the appellant is seeking to rely on.
Guarantees by
Guarantees that I would say are, as noted by counsel for the appellant, fundamental guarantees or protections that are afforded to an individual. And this is further supported by the 2023 CAS Award of ADGAS and UEFA, which noted that CAS jurisprudence is clear that procedural rights cannot, in principle, be determined from the point of view of criminal law concepts enshrined in, and I quote verbatim, Article 6 of the European Convention of Human Rights. The strict application of criminal law principles in disciplinary proceedings would prevent the fight against match fixing from functioning properly. And in the context of sport, the privilege against self-incrimination may not be easily invoked in a disciplinary proceeding. However, even if we agree with counsel for the appellant that the privilege against self-incrimination can be invoked, there's a very high threshold to be met. As noted in Valky, the only situation where this privilege may extend to private investigations, which may be applicable to CAS jurisprudence, is where there's a clear and imminent danger that the privilege against self-incrimination would be circumvented, which is noted to be an extremely high threshold. And if I could first inform the panel that CAS in Jerome at paragraph 266 noted that real and imminent danger only exists if there's a collaboration between the sporting organization and the public authorities in which both parties would share information which may prejudice Mr. Fortuna's protection against self-incrimination. And the most crucial fact against such a threshold being met is that the Iridonian Public Prosecutor's Office explicitly refused to share evidence with FIFA. If I could turn the panel's attention to para 15 and 16 of the record at page 4, the prosecutor stated that they will only share information after their investigation was concluded and the case was ready for court. This refusal demonstrates that states' authorities are protecting the integrity of their own criminal process, not using FIFA as an investigative proxy. If there were indeed an imminent danger of rights circumvention, the state would be actively collaborating with FIFA to bypass its own evidentiary hurdles. Instead, the two tracks are operating independently, which negates the claim of a collusive circumvention of Mr. Fortuna's rights under Article 6 of the ECHR.
What about, I mean, so his father, the player's father, has allegedly requested for him to cooperate in terms of the alleged match fixing, right? If there were such facts pointing to that collusion, alleged collusion, or perhaps things which were detrimental to the player, even if he did not participate in the match fixing, if he reviewed information in his mobile phone, could there be imminent danger stemming from the fact that his father has ties to, I think I read somewhere, ties to the underworld or something?
Well, if you're talking about communications between the appellant and his father himself, wouldn't it naturally follow that any communication found on the appellant's phone also be found on the father's phone? As the nature of communication is that it's two-way, that will be located, and such messages will have been located on the father's phone as well. And notably, in our proceedings today, it is the appellant, Mr. Fortuna, against FIFA, not the appellant's father. And therefore, in today's proceedings, we must ensure that the appellant's rights are respected. Mr. Fortuna's father is of a separate issue, and he faces his own his own criminal trial before the Iridonian public prosecutors, which have to, by their own methods, find a way to find Mr. Fortuna's father guilty of the crimes they are accusing him of. And crucially, as noted in Article 12, subsection 5 of the FDC, this court is bound by the facts that's already present to them. And essentially, this means that if the appellant had indeed refused to hand over his handphone, which he had, the courts are bound by the evidence that are already present to them to make a finding. They are not allowed to use maybe the doctrine of adverse inference from the fact that the appellant had refused to hand over his phone to find that the father was guilty of match fixing or that the appellant himself was colluding in match fixing. Rather, they are confined to whatever they've already been provided to find whether the appellant himself was guilty of match fixing under Article 20 of the FDC.
Is there anywhere in the record which points to some solutions or workarounds proposed by the player himself? I mean, what I'm thinking of is, instead of handing over the whole mobile phone, perhaps there could be some redaction or selected messages where he can review to FIFA. Was there anything of that sort?
On the facts of the case, there currently is not. And notably, with regards to Article 6 of the ECHR, which is the right against self-incrimination, I do believe that the respondent and the appellant can come to a consensus as to what degree of information can be shared from his phone. And notably, we have to ensure that his rights against self-incrimination is protected, but we do believe that mutual cooperation can allow us to identify any information in his phone that do not breach his right to self-incrimination, but at the same time do aid in our processes in finding whether he had indeed be liable for match fixing. Crucially, we do note that it does have a certain optic that the appellant, despite claiming that he did not collude in match fixing, refuses to hand over his phone. And to ensure that he indeed is innocent, we would like to try our very best to help him by ensuring that his right against self-incrimination isn't violated.
So my question was there anywhere in the record where either FIFA or the player himself suggested all these solutions? That's all.
No, Mr. Arbitrator.
Okay, sure. Then go on.
Actually, Mr. Arbitrator, that about sums up my submissions. If you have any further questions, this concludes my submissions. I'll now hand over my time to my co-counsel, Mr. Ramesh Kanna, who will address the remaining 2 issues on appeal. Thank you.
Yeah. So, Mr. Ramesh will be speaking on behalf of FIFA, right?
Yes.
Hence, with the understanding that the appellate has submitted on issues C and D. Okay, then if that's the case, please go on.
Good evening, Mr. President. My name is Ramesh Kanna and I act for the respondent, FIFA, and I'll address 2 issues in today's submission. Firstly, whether the anonymous witness statement and the anonymous email are admissible, and secondly, whether the appellant has breached Article 20 of the FIFA Disciplinary Code. Now, with regard to admissibility of the anonymous evidence, the legal framework that is to be adopted is firstly the FIFA Disciplinary Code and secondly the CAS jurisprudence. Both these sets of legal frameworks have to be satisfied in order for both these pieces of evidence to be admissible. Now I note that Mr. President had earlier posed the question of what rules of evidence that he is bound by, and this is relevant for this issue as well, given that it's an admissibility issue. And it's worth noting that in the CAS code, there's no direct article with regard to anonymous evidence of admissibility of anonymous evidence. However, there are broad conceptions of fairness, such as equality of arms, which is stated in Article R44.2 of the CAS code. And what this translates to is, this is interpreted by the CAS jurisprudence such as the 2010 decision of UEFA and Orikov, where the panel confirmed that comfortable satisfaction is the correct standard in corruption cases, and explicitly noted that corruption is typically proven on the basis of indicia and circumstantial evidence and not proof. So basically what these line of cases do is that they have interpreted this broader idea to come up with rules within case law. However, there's no particular article within the code that directly addresses this issue.
Then what about Swiss law?
Unfortunately, I do not have that at hand, Mr. President. But it's worth noting that this is also aligned with Article 39 of the FDC on evidence and standard of proof, which provides 3 key points. Firstly, that any type of proof may be produced, and second, that the judicial body enjoys absolute discretion regarding the evaluation of evidence, and thirdly, that the applicable standard is, once again, comfortable satisfaction and not the criminal standard of proof beyond reasonable doubt.
Judicial body. Those are the FDC, right? That's the FDC, right?
Yes.
What's the definition of judicial body? And is the CAS panel a judicial body?
No, Mr. President, the CAS panel would not fall within the definition of judicial body as conceived by the FDC. The FDC governs rules of evidence within disciplinary hearings that are conducted by the FDC. However,
So you're saying that the CAS panel is not bound to those rules?
it's not bound by it. However, given the fact that I am here to prove admissibility, I have to prove that it coheres with both the FDC standard and the CAS jurisprudence standard. Now, the 2009 CAS decision of FK Pobeda and UEFA.
Sorry, just a little bit of annoyance for me, but can you say CAS and UEFA?
CAS and UEFA.
Yep, thank you.
Understood. So similarly in this decision, the CAS aligned match fixing with doping jurisprudence, accepting that disciplinary bodies can rely on indirect evidence provided they meet the comfortable satisfaction standard. And now when we apply this to the present case, firstly with regard to the anonymous witness statement, which is on Exhibit 2, page 9 of the record.
Page 9 of
Mood
the electronic record.
the mood form.
Sorry, page 9? Which exhibit are we talking about?
Exhibit.
If I could refer to Exhibit 2.
Okay. Okay, I'm there.
Under the section titled My Reasons for Requesting Anonymity, alright, the witness explains that he fears reprisals because the appellant's father is rumored to be connected to criminal organizations. Now, this is a textbook Article 43, subsection 1 FDC situation, where disclosure of identity may trigger threats or intimidation. Now, substantively, this statement is both relevant and reliable because the witness personally observed two key things. First, the appellant was on the phone with his father the night before the match, and second, the appellant shouting that his father should stop pressuring him and that he cannot go along with everything. Now, CAS in the past has accepted this type of evidence where anonymity is justified and the evidence forms part of a corroborated mosaic. This was seen in the 2010 CAS decision of Orikov, where the panel stressed that corruption is by its nature concealed and that sports bodies must often rely on indirect and non-traditional evidence, including information from confidential sources, to reach the comfortable satisfaction standard. And here, our situation is similar because the anonymous witness is one brick in a much larger evidentiary wall. Now, this can be seen when we look at the anonymous email as well, which alleges a transfer of 50,000 dodgy coins to the appellant's father. Now, this email is likewise admissible and it is importantly heavily corroborated because in Exhibit 5, we see that the prosecutor's press release confirms that Mr. Luke Fortuna's dodgy coin wallet is under investigation by the Specialist Sports Integrity Unit. And secondly, under Exhibit 4, we see that the WhatsApp screenshot shows Luke the crook acknowledging receipt of the last part of the coin from the syndicate. And thirdly, Exhibit 1, the Genius Sports Report records massive, unjustifiable betting for Comet Land and a red integrity alert, exactly the kind of pattern one would expect if a syndicate had paid a key insider. Now, CAS jurisprudence is clear that anonymous intelligence is admissible if it is corroborated by objective data. This was seen in the 2014 CAS decision of Sebaspo and UEFA at paragraphs 124 to 125. And CAS accepted UEFA's betting fraud detection system reports together with other indicia as sufficient evidence of manipulation despite the absence of direct confessions. This was also echoed in the 2013 CAS decision of Besiktas and UEFA. Here, the anonymous email points to crypto payments, and the prosecutor's announcement and the WhatsApp chats and the betting report independently point in the same direction. This is exactly the type of corroborated anonymous intelligence that CAS routinely accepts. And therefore, our position is that the comfortable satisfaction standard is met for both these pieces of evidence. Now, furthermore, if this were not enough, moving to the match-fixing matter, all the hallmarks of match manipulation are present. First, the match was graded red by Genius Sports based on dramatic and unjustifiable odd movements for Comet Land and the suspension of markets by major bookmakers such as PiniBet, BetX, and BetAsia.
Sorry, the report maker, how objective is it?
Apologies, Mr. President. Give us a minute. So, okay, Could I direct Mr. President to Exhibit 1?
Yes, I am here. It's a long report, I think.
Okay, we believe that there's actually a printing error with the page, the pages.
Because all of them show page.
Yeah, the correction. Yeah, so could I refer you to the page that's 7 pages from the last page?
7 pages from the last page of.
Exhibit 1.
Okay, maybe you can tell me, you give me a sentence or phrase I can use to find. What
Maybe
you
you
want.
could control F semi. Oh, sorry, you could just control F offside technology.
Off-site.
Offside. OFFSIDE. Spacing technology. Then it should lead you to this section called Introduction. Where
Yes.
Genius Reports goes into great detail about what sort of technology they use and
Yep.
the
Okay.
extent of
So
reliability.
your point on the objectivity of this
It falls back on the technology that they use to.
so you are relying on you're trying to say that genius is objective based on what you're saying.
Yes, and we do not make this statement on thin air because these sorts of reports that talk about betting anomalies have been accepted as objective evidence in previous cast jurisprudence.
I'm not doubting that. I'm just wondering about the provenance of genius. Is there any external source which can corroborate your assertion, which is that genius is objective? It is a credible source.
Okay, yes, Mr. President. So if I could get you to control F the phrase the software,
Okay. Yeah.
it would lead you to this section where they state that Genius IQ's Dragon software is now active in 200 plus venues across 33 countries. So the widespread adoption of this particular software that this provider uses shows that it is reliable. And not just that, they go on to add that this robust data set empowers Genius to deliver evidence-driven conclusions unmatched in quality and
No, I have no doubt whatever they say might be true based on what they say it is. So what I'm trying to look for is whether other sources say that Genius is a credible software provider.
So-
That's all.
Our submission for that would be that this software is in practice and in use in 200 other venues across 33 other countries.
So that's what they say. So is there any external source I can refer to within the returns?
I understand the issue. So Mr. President does not believe the claim. As
No, I don't want to. It's not that I don't believe the claim. I believe that they're making this claim is probably on good grounds, but I want to be comfortably satisfied. And if I want to be comfortably satisfied, then there should be some other sources saying that they are objective, credible.
Well, Mr. President, I would go on to add that the FIFA Appeal Committee has also relied on this evidence.
Where can I find it?
You can find it in Exhibit 7.
Right. Okay, I think I am there. Is there
So if I could refer you to paragraph 33 under that exhibit.
Yeah.
So the FIFA Appeal Committee also trusted Genius Reports enough to rely on their report when making their conclusion.
Okay, fine. I get what you're trying to say. Yeah. But there's still basically your client who's saying Genius report is good, it's credible, it's objective. Probably something one step removed would be better. But I get your point. Yeah.
Yeah, so we wish to highlight again that CAS has repeatedly noted that match fixing is organized, covert, and designed to leave no direct trace. So therefore, tribunals must therefore be able to rely on indirect and even anonymous evidence when the evidence is supported by betting data and performance analysis, as in Orikov and Poveda. And to conclude, this is the situation that this tribunal faces today. Therefore, both the anonymous witness statement and the anonymous email are admissible as they squarely fit within the CAS jurisprudence and Articles 39, 43, and 44 of the FDC. If members of the tribunal have no further questions, I'll move on to the second issue, which is whether the appellant did violate Article 20 of the FDC. Now, Article 20, subsection 1 of the FDC provides that anyone who directly or indirectly, by an act or omission, unlawfully influences or manipulates the cause or result of a match, or conspires or attempts to do so, shall be sanctioned. Now, if this were to be broken down into three simpler pieces, firstly, indirect involvement is enough. The player does not need to receive money himself. Acting under pressure from or in coordination with a third party, such as his father in this alleged case, or a syndicate, still falls squarely within Article 20, subsection 1. And secondly, attempts and conspiracies are still punishable. The fix does not need to be perfect or fully executed for liability to arise. And finally, the standard of proof is comfortable satisfaction as confirmed in the CAS cases of Orikov, Pobeda, and Sivaspor. Now, match fixing is never shown by one piece of evidence. The CAS panel must assess the entire mosaic of circumstantial indicators. Now, firstly, we should look at the betting anomalies. If I could lead the panel to Exhibit 1 to highlight the betting anomalies of the Genius Sports record. So,
Where do you want me to turn to?
if you could look at the pre-game betting section.
Okay, it starts with bookmaker coverage.
Yeah, so then could I get you to scroll down the paragraph which starts off with the markets remained highly stable.
Somewhere in the middle, okay?
Yes.
Yep.
So, in essence, before the match, there was strong betting against Iridonia, despite Cometland being bottom of the group, with 1 goal scored and 12 conceded. Now, the odds for Cometland shortened dramatically with no sporting explanation. And in play, within 20 minutes, Cometland went from a huge outsider to a favourite, even though Iridonia dominated possession and chances. And around the 22nd minute, Pinibet and other major operators suspended markets immediately before Cometland's first goal. Now, CAS has already accepted in Pobeda and Sivaspor that such sharp, unjustified betting movements, especially when they lead bookmakers to suspend markets, are a strong indicator of manipulation and can be decisive when corroborated by other evidence. Now, here these anomalies are not just odd, they align perfectly with financial transfers to the appellant's father, and with performance anomalies on the pitch, and the witness evidence of the pre-match pressure. So our submission is that, indeed, this level of corroboration that CAS jurisprudence looks for has been achieved in this particular case. Now, to develop further on the performance analysis, we submit that there was intentional underperformance on the appellant's part, because the Genius report analyzes and identifies a series of highly unusual actions by the appellant. Now, for the first goal, there was a misjudged, lofted pass over an oncoming forward, which, if I could refer you to the section titled Goals.
Control performance analysis.
Right under performance.
Right, so now Genius is going from analyzing betting patterns to technical football analysis.
Yes, Mr. President.
Did they list who did the analysis, or again, it goes back to the point that I was trying to make, which is how credible are they? but it is okay if you cannot find any information on there. Yeah. So you're saying lofted pass.
Yes, which caused the ball to roll back into the net, which was a blunder in that game. And we do note the nuance that such movements are not uncommon in other games. However, this has to be seen in totem with the mosaic of evidence that's present. Because this was not the only blunder. Earlier, the player also allowed a corner to pass right through his hands.
Now, where can I find that again?
First,
That would be the next page, right? Passages of interest.
yes.
Okay, 5 minutes 54. So the time is 5 minutes 54. Donia's goalkeeper
Yeah,
ventured off his line. Okay.
and it was and the player allowed to and the player allowed the ball to pass right through his hands, and he also delayed a clearance until the ball rebounded off an attacker towards the goal. So our position is that throughout the game there are repeated poor positional decisions on the part of the appellant.
Hold on. So how many decisions are we talking about? I mean up to 5:54. That's 2, right?
Yes.
So what else is there? Slow back pass. That's the next one, right?
Yep.
To get unnecessary extra touch.
However,
Mhm.
what is to be particularly noted is that these poor decisions that the appellant would arguably state are genuine began right at the moment when the markets were suspended. In the sense that there is the timeline is such that it's hard not to notice that the players' poor decisions occurred right when the betting movements.
Sorry.
Why?
So when did the betting movements move again?
At the 22nd minute.
22nd minute. So from the 22nd minute,
This was right before Comet Land's first goal.
so they were just 4 in all, right? 4 issues with the goalkeeper.
Yeah. And up until this point, there were 12 goals that were conceded on Comet Land's end. So
Sorry, 12 goals.
sorry, apologies, I retract that statement. I think that was
Okay.
factually wrong.
Okay, I mean, I hear where you're coming from. I do see that there are 4 mistakes here. But I'm not sure if I'm comfortable with saying 4 mistakes alone would amount to being involved in match fixing.
Yeah. So to clarify, Mr. President, we're not stating that this is the only evidence that corroborates with the notion that the appellant had intentionally underperformed, but also the fact that there were crypto payments allegedly, and which shows motive and links to a syndicate.
But crypto was paid not to him, right?
To his father.
To his father.
But when we look at it together with the fact that, according to the witness statement, he was being pressured by his father to allegedly underperform.
But I think the witness statement also said that he was quite vehement about not complying with his father's wishes. So, I mean, I'm speculating perhaps, but could it be that he also pressured by his father and he didn't want to do it, and he was affected by those arguments, and that's why he underperformed, rather than him being told by his father to underperform, and as a result he underperforms. Then I think perhaps GDS needs to come up with a psychologist to interview the guy. Have one more section on their report.
I understand the concern that Mr. President has, and in this regard, CAS jurisprudence is not considered a mental element for this particular article. Rather, it's one of strict liability, arguably, in that the CAS panel usually just looks at objective evidence of how the player has performed and the surrounding circumstances such as betting anomalies and other evidence that corroborate the claim that the appellant has been involved indirectly or directly by an act or omission.
So okay, I mean, assuming that these are all possible scenarios or interpretations of the phone call. One could be that he was pressured and he complied, that's why he underperformed. The other being he was pressured, he didn't want to comply, and but because of those arguments, he underperformed. So if I were to have all these scenarios before me, so two questions come to mind. First, can I, as a panel, and I'm not psychologically trained or psychiatrist trained, can I make that inference that perhaps the scenario B was the case, that he, because of those arguments, his mental state was affected, and that's why he was underperforming. And second, my second question is, how do I consider all these scenarios before to come to a decision?
Okay, so with regard to Mr. President's first question, as far as the CAS jurisprudence goes and the CAS code goes, the CAS panel would not be fit to psychologically determine the mental state of the player. However, this also goes into answering the second question, which is that the other possible theory that Mr. President had earlier put forward, which is that the player might have underperformed due to the pressure, we would argue that this theory falls apart when we consider the fact that the underperformance matches the exact timing that was required for the betting anomalies to occur. Because if it was a case that the player was pressured from the very beginning, then these mistakes would have occurred throughout the game. Yeah, because at the 2-minute mark, the player was still performing well. And this can be seen at not the 2-minute mark. At the time 82:43, the player was still performing well.
82:43, that's like almost at the end of the match already. So you're saying that for the whole match he performed well?
As in, he performed well at the end of the game, towards the end of the game. However, the underperformance was only required during the time window where the markets had been suspended. Thus, our argument is that it could not have been a scenario where the underperformance was something that was throughout the game that he was impacted by because of his mental state.
Okay, so what you're saying now is he was instructed to underperform at specific timings. Right. Okay. That I understand. Okay, go on. And I had a second question. Yeah.
Which is what
if I had all these scenarios before me, and assuming the answer to my first question is I can make that inference. So how do I consider all these scenarios before me to come to a decision?
So what the CAS jurisprudence is instructed is that when there are more than one particular scenario that has to be accounted for, the tribunal has to look at all the surrounding evidence and consider holistically which theory makes more sense. And in this regard, that is why we submit that given the underperformance occurred at this particular time, the lack of the fact that it occurs at the particular time that is required for the betting anomalies to be exploited shows that the theory that the respondents put forward is the most viable one that the tribunal should look at. That brings me to the end of the second issue.
Are there more issues to cover?
That brings me to the end of my submission.
And I do have one more question. So I mean, given that your opposing counsel is not around today, how would that play out? How would that play out? Does it affect this particular hearing? Because as the opposing counsel did mention, I do need to hear him, right, on the issues that you're presenting. Otherwise, it would be a breach of fair trial, right to be heard.
As per Article 47 of the CAS Code, hearing can be considered in full.
I understand what. Okay, what do you mean by de novo?
Unfortunately, I don't think I can assist you on this matter,
Okay,
Mr. President.
right.
I'm quite fully informed in this regard.
Okay, I understand. Alright, and I guess that's all I require of you for now. Are we moving on to buttons or something? And who will be the one?
Mr. President, 2 points in rebuttal.
Hey, hold on, I'm not ready.
Oh, apologies, Mr. President.
Okay, yep.
Mr. President, do you have a preference for time for rebuttal?
No, just go.
Have a quick, okay, just 2 points. First, the poor performance can be explained. And second, there's no actual link between.
Sorry, you are addressing which issues again?
I will rebut the respondent's issue D. C on the betting report, the performance.
C is on the anonymous evidence, right?
Or D, apologies.
So you're addressing me on the match fixing, the substantive issue of match fixing,
Yes.
and that's it.
And also the issue of the witness statements, the exhibits, the anonymous witness statements.
Okay, so basically C and D.
Yes.
Alright, and which one do you want to?
I'll start with the first one, the D.
Sorry, D is the match fixing.
The match fixing.
Okay. Okay.
The respondent argued much of his submissions on the betting report analysis, and as queried earlier by Mr. President, it's very objective. May I direct the President to Exhibit 6, which is titled page 15, Control F, My Relationship with My Father. Exhibit 6 at paragraph 10.
Paragraph 10. Yep.
So here, I quote, "I had been feeling a bit under the weather." Line 3, "I discussed this with the team's doctor." And so here on the record, he had seen the doctor, had been feeling unwell, and still chose to play. And as a result of which, this could be another reason as to why there had been underperformance of the match. And if there's no further questions, I'll move on to the second point. If I can refer it's our submission, there's no causal link between the father and son. And the evidence, the exhibit 3, which is the email regarding the 50,000 Dogecoins, and the press release exhibit 5 from the public prosecutor's office does not sufficiently establish causal link. And that's because in exhibit 3, if President can follow me there, it's exhibit 3, you can control F, date, email from anonymous source. So here in the 4th paragraph of the email, it says there was multiple.
Starting from the words what I know,
Yes,
what I know.
Correct. If you see here, I'll quote, "The transfer was made in multiple transactions, with transfers happening from the end of September up to the 17th October 2025. And if the President will indulge in returning to page 3 of the record, page 2, paragraph, page 3, page 2, paragraph 6, the match occurred on 17 October 2025, and therefore all the multiple transactions that were paid was prior to the actual game. And this we submit that if there was indeed match fixing, surely these payments would have been paid after an agreement had been made and after the actual game had been fixed. This creates a level of uncertainty in the respondent's case. And then as well as in, just to conclude, Mr. President, Exhibit 5 of the press release here, they only confirmed that Mr. Fortuna had provided access to his Dodge wallet. And
Sorry, Mr. Fortuna as in his father.
Yes, Mr. Luck Fortuna. And that at the highest, it could be inferred or pitched that the father may have had some investments in crypto coin or had an involvement with some criminal syndicate that was unrelated to my client, Mr. Fortuna. If there are no further questions, this brings me to the end of my photos. Thank you, Mr. President.
So who's doing the rebuttal? Sorry, sir. Report. Yeah, go ahead.
Good evening, Mr. President. So, appellant counsel's first rebuttal, the essence of it was that the underperformance was not intentional and that this is supported by the fact that the player was already feeling under the weather prior and this had been informed. However, our submission to this would be, if indeed the underperformance stemmed from fatigue, then it's not explainable why the underperformance had to occur right at the moment the betting anomalies could be exploited. Because if fatigue was the issue, then the performance should be gradually deteriorating throughout the game. However, as we had seen in my earlier submissions, up until at the 80th minute, the player's performance had drastically improved. That is right after the markets came back into position. Therefore, we once again wish to highlight the fact that the underperformance had occurred right at the moment that was required for the syndicate to exploit the betting anomalies. And for this reason, we would reject the theory or the idea that the underperformance was genuine.
I don't know, man. I mean, have you heard of a team called Manchester United? They were very well known for many years for the last 10 minutes of the game. Because they could be 3-0 down, they could be 4-0 down. Okay, maybe not 4-0, but 3-0 at least. In the last 10 minutes, they would score enough to level or even from the opposing. And it could be the other interpretation that, perhaps the Iridonian coach had trained his people in this way. So what I'm saying is that, can we really say that the players underperformed and only within the last 10 minutes they started to have a second win and do much better because of the betting patterns? I don't know. It seems to be a bit far.
I'll answer that question in two parts, Mr. President. So firstly, with regard to the potential analogy with Manchester United, we note here that prior to the 80th minute where the appellant started playing proper, he was, allegedly according to the appellant's theory, so fatigued that he made poor decisions such as allowing the ball to pass right through his hands. Now, we would definitely argue that this would not have been within the coach's foresight or would not have been a game plan because it directly penalizes them. And it does not make sense to say that if this was caused by fatigue, then somehow the fatigue does not allow him to play poorly at the 80th minute, further into the game when one would argue that the player has probably gotten more fatigued. Thus, we would still argue that this theory does not make sense. And moreover, we understand Mr. President's reservations in solely looking at this particular player anomaly. And for that reason, we would say that this claim that there was intentional underperformance is corroborated by not just the playing anomalies, but also the betting anomalies, and also the witness statement, and also the dodgy coin transfer. Now, if Mr. President has no further questions with regard to the first rebuttal, I'll move on to address the second rebuttal, which is, in essence, the appellant has looked at the timeline and has stated that given the 50,000 dodgy coin transfer had occurred prior to the game, it must have been a separate event that is not linked to the game, and that and his basis for stating this is that he claims that if the transfer had occurred prior, there's no way that a particular agreement could have been reached beyond that point in time. However, our submission in this theory is that the 50,000 dodgy coins was a reward to Luke Fortuna for getting the appellant to underperform. Thus, that's the first part of the agreement. And their end of that agreement would be to underperform such that the syndicate can exploit the betting anomalies and possibly earn more than 50,000 dodgy coins. Thus, the appellant's theory falls apart when we understand that the 50,000 dodgy coins is not being stated as the returns of that whole transaction. Rather, it's the first part of the transaction which was promised to the appellant and his father in order to deliver their end of that promise, which is to underperform. And this theory corroborates with the betting anomalies, with the timing in which the player had underperformed, and also the witness statement. So I end my rebuttals.
I think there's a lot more fun to be had at the performance part.
Yeah.
Before we get more questions there. And you. Not very convincing by your answer, but okay, you were quite trying to layer it on, so that was okay.